As Rachel has mentioned, I will speak a little bit about Section 33B and the issues arising from this section. Maybe by way of a bit of background, I mean, thanks to the good work of your organization and many other campaigners leading up to Yong Wee Kong's case, the government decided that the mandatory death penalty for all cases was completely inappropriate, and they had changed, and they had introduced Section 33B of the Misuse of Drugs Act, which provides that innocent couriers, meaning drug traffickers who do not play any role higher or apart from just making the delivery, who can show either that they have provided substantive assistance to the state, or if they have, or if they had a mental issue which contributed to the offense, the judge then in these two cases has discretion to sentence them to life imprisonment with caning as far as where there's a certificate of cooperation, or without caning where there is a mental illness involved. So, I mean, thanks to you guys, the law, I mean, we have come some way. There is, of course, still some way to go. With the new Section 33B, many of our old clients were sent for psychiatric evaluation, both at the IMH and also we had sent them for private opinions. Several of them qualified and were resentenced to life imprisonment. In other cases, they were provided with a certificate. It left us in a position to dealing with all the old cases where the government, for whatever reason, refused to give a certificate, and we were unable to find any cause to assist by getting a medical opinion where we could use to argue that they were suffering from a mental impairment. Now, what we decide, I mean, what we felt that was unfair, most particularly, was that it was not the court who decided who provided assistance or not. The issue of who provided assistance is determined solely by the Attorney General's chambers, and that decision is not appealable. You can't even apply for judicial review against that decision, save only on two grounds. You must show that the AGC acted in bad faith or with malice. The traditional avenues of judicial review, which is unreasonableness, no natural justice, arguably were excluded by the section. So now, the context of how to look at Section 33B and the issue of the government deciding who to give a certificate to, you got to understand that in any democracy we believe in and we practice what's known as the separation of powers. You have legislature, which creates legislation. You have the executive, the government. The AG is also part of the executive. And you have the judiciary. Now, on an issue of who to charge, what to charge with, that is provided for by the Constitution. It is the AG's responsibility and nobody else's responsibility. His decision on who to charge, what to charge with cannot be questioned, save for where he acts in bad faith. Now, once the AG decides who to charge and what to charge with, I mean, his decision-making role ends there, and his office prosecutes the offender in court. He takes a position of the state and proves his case against the accused. Ultimately, whether the accused is found guilty, whether the accused is found guilty or not, what he is sentenced to, Article 93 of the Constitution provides that it's for the judiciary to make judicial decisions. But if you think about it very carefully here, what happens is the accused person goes through a full trial, or the judge decides on guilt or innocence. He decides whether the person is an innocent courier or not. And then the matter pauses there. For the Attorney General to decide then whether to issue a certificate or not. So if you think about it carefully, who is making the decision on whether this person should live or die? It is not the judge. The decision ultimately, from all intents and purposes, is being made by the executive, which means, what my argument is that, look, the executive can decide who to charge, but they cannot decide what happens to that person. They cannot decide sentence in each individual's case. They can set laws, they can execute laws against classes of people, but what they cannot do is they cannot say, Mr. A, I'm going to look at your case and I decide you suffer death, you suffer life. No, they can make laws and they can implement those laws, and those laws apply across the borders for the judiciary to make findings of guilt and to pass sentence. You cannot have the executive looking at person A, now I decide for you, you live, I decide for you, you don't. That's not the role and function of the executive in any democracy. So that is the argument, that was the argument we made, and we invited the court to find that the process which our clients had gone through, where their liberty, their life in particular, there's an article in the Constitution which says that life and liberty cannot be taken away save in accordance to law. And law would include natural justice, and it would include, it would include natural justice as well as the constitutionality of the process. So what we argued is that in these cases, life was not taken away in accordance with law because it was not a judicial decision, but rather it was an executive decision which took away life, and that's not permitted. Now, the difficulty that we had in our argument, well, we tried to tackle it at two ways, at two levels. First, to say that, look, these sentences should be set aside because they're illegal, they're passed contrary to Article 9.1. The difficulty we seem to have is that, I must be clear that these are all arguments that were made publicly in court and are publicly available. And the questions that the court asked are also publicly available. What they were querying me on, yes, perhaps Section 33B is unconstitutional because it puts the power to decide life or death in the hands of the executive. But what is going to be your remedy? If we hold Section 33B unconstitutional, then you're back to the mandatory death penalty, which is not what I want. So that was a difficulty that we had because they refused to look at it holistically and say the process by which they went through is unconstitutional. They were just focusing on the legislation, and they seemed to be of the view, or rather they seemed to question that Section 33B was a carve-out from the mandatory death penalty, and if I was entitled to any remedy, it would be the excision or the removal of Section 33B, which would not be helpful for me. The other argument we made was that the court can interpret Section 33B to make it consistent with the Constitution, and that is to interpret it to mean that it's the judges who should, at the end of the day, the prosecution can first decide who they want to give a certificate of cooperation or not to, but really because judges have judicial power under the Constitution, it would really be still for the judges at the end of the day to scrutinize each case and to see whether the certificate was properly given or not, meaning if it was not properly given, the judges should order the Attorney General's chambers to give it, and the other way around. Ultimately, the judge has to have the final say. That was our argument, but it didn't seem to have much impact. Anyway, we are still waiting for the judgment from court, and we hope that there'll be something there which helps us take these points to another level, and hopefully your organization can take these points further and build on it and see how we can eventually cause the government to remove the death penalty totally. I think that is what I have to say. Maybe I'll take a few questions, or maybe some questions.
Questions? I have one. Does it cost a lot to apply for a constitutional challenge?
Well, it does not, because, I mean, Ravi and myself, we generally don't, in these cases, we generally don't charge. Yes.
Hello, hi. Thanks for sharing everything you did. I just have a question about now that the amendment has been made, what happens in certain situations where clearly the person is not able to provide the assistance that he's being expected to give? Like, I mean, what if he really doesn't have any information? What if he doesn't have, he never made face-to-face contact with the person who gave him the drugs, for example? And is there any sort of provision to take that into account, or is he just forget it? There's no way you're going to get that certificate you were talking about?
The answer to the question is no. There's nothing that anyone can do for him under the law, which is ironical, because, and the reason I say that is because it is the people who really are who are at the lowest level of the chain who really don't know anything. It's the guys who are further up who will be able to provide information. So that's the irony of the law as it is now. The lowest of the lowest person in the chain really will find it extremely difficult. And this is the person that I believe that the law was meant to protect, the most innocent of the whole chain. But that's the irony, and I think that's something that should be addressed.
Hi, so I have a related question, and it's, to my understanding, is that it's not just whether the person cooperates, but the cooperation has to lead to an outcome that they feel satisfactory. So even if I give numbers and all the information, but they can't find the guy, or they're not satisfied with the outcome, they're not able to prosecute someone else, that it's not. So the threshold seems to be very high. Is that a correct understanding?
That is what the position seems to be. And the other issue is this total and complete lack of transparency. Because in each case, I think even in Chan Chun Ying's case, originally no certificate given. Ravi took out an application to court for judicial review. Unfortunately, he lost the application, but undeterred, he filed an appeal. Suddenly, the prosecution changed its mind and issued a certificate. In all these cases, we don't know what the information provided was. We don't know what the outcome of this information was. I have my doubts sometimes as to whether people who get certificate, whether there was actually a positive result from the information given. But unfortunately, it's all not transparent. And so it's very difficult to tell.
And also there's one additional problem, is that a mule could give a very good information. But if the officer is very bochap, then, or not so proactive, in local parlance. I was just thinking that who is not, alert. But anyway, after the biryani. No. So some officers are proactive. So it all depends on the capability of the individual officers. And that, as what Eugene has said, we need transparency of not only the decision making and the decision making process, as well as the effectiveness of the investigation, and subject that information to test, i.e. cross-examination in court. And secondly, when, for example, in Wee Kong's case, he was granted certificate and we are happy, and Chun Ying's case also, he said that the mastermind was calling the police investigation officer, he was calling him while he was being interrogated, and he said, look, this guy is calling, please investigate. But there was no follow-up on that, and that was one of the grounds of a challenge we did. Now the thing is that that information was also not followed up. And how is it that, how much information can actually these people give? And Wee Kong's case, the case was already, he was caught in 2008, the law was amended in 2012, and then, by which time, like 5 years have passed. How is it that he got this certificate, which I'm very happy, but after 6 years, it disrupted the syndicate? what happened 6 years ago. You know, so it's beyond comprehension how this, and we're talking about life and death. And also this entire mandatory death sentence when when this challenge was maintained on behalf of Yong Wee Kong in 2009, when you look at all the arguments that was presented, it was in 1973 when the law was passed, it was meant to tackle the masterminds. It was not meant to actually give death sentence to the mules. And that was already the original plan that Parliament had, and that was actively debated even in 1973. And again, when the law was amended in 2012, again, the focus was against these big-time syndicates and not the mules. And what is very, very crucial in the case that Eugene is currently doing is that all these 4 cases, if I'm not mistaken, are mules. And they were actually declared by the court in the observation during the course of the proceedings and the judgment that these are all mules. And this will be those innocent mules we are talking about who should satisfy the court, or rather the prosecution, for there to be a certificate granted to them. So these four cases, which is the subject matter of this constitutional challenge, is very, very crucial. So we as anti-death penalty campaigners, and of course as concerned citizens, which whatever political views we hold, that aside. But because this is so troubling, that the law has been amended, but because of these injustices, we need to carry this campaign further to tackle these issues.
Eugene, just to check. You see, the amendment, right? For drug mules, I think it's pretty clear. Based on the amendments, you would the court expect you to provide certain evidence, and then therefore you'll be granted the certificate of corporation. But does this amendment create a problem in which a person is truly innocent, a person who is truly does not have any knowledge of what happened, is being kind of caused to plead guilty or confess to a certain crime which he did not commit, on the basis that he can be spared of a certain death if he confessed to the crime in which he commits and therefore able to exist. Because if he totally denied but yet still end of the day gets sentenced guilty, he would never be able to be granted this certificate of entitlement.
Yes, I think that what you say is a real danger, because how the process works is that when a person is charged with drug trafficking, the burden is on the accused person to prove on the balance of probabilities that he did not know that he was in possession of a particular drug. So evidentially, I mean, whether you're innocent, whether you're not, ultimately you bear a very high evidential burden to prove your innocence. So theoretically, it may very well be that innocent people are found guilty simply because they cannot, they don't have the evidence to prove a negative that I didn't know, which is so hard to prove. So what happens to these people is there's absolutely no chance of a certificate, well, at least based on what the government holds the criteria out to be. Because if you're completely innocent of drug trafficking, there's going to be no information you'll ever be able to produce. I suppose if you're very, very clever and you find yourself in that position and you lie and provide information, theoretically, I suppose you may be better off than fighting the case if you were innocent.
I have one more question. So, I mean, I think it's quite a well-known fact that the burden of proof is on the accused in this case, but are there any grounds to argue that that's unconstitutional, given that generally you're innocent until proven guilty and that's a principle the court upholds otherwise? Or is it, even if it's not unconstitutional, is it worthwhile to push that argument, to say it should be changed such that the person is innocent until proven guilty?
I mean, as far as the law and the Constitution is concerned, there's nothing legally wrong with the state reversing a burden of proof. So, and I mean there's good law in a lot of countries where certain things would only be in the knowledge of an accused person, and so there is rationale why the state is allowed to reverse the burden of proof. So I don't think that, I mean, legally there can be a challenge, but from a moral perspective, I mean, we have to look at morality as well. From a moral perspective, where the stakes are so high, where you're facing a death penalty, I mean, should it be the case that the burden is on you? Perhaps, I mean, one way people can, or the government can deal with this is to have a tiered system, such that where, because I mean, at the same time, we don't want to make our country into a drug haven, and there has to be laws enforced properly. So one way could be a structured system where, if the state is able to prove beyond a reasonable doubt, then perhaps the maximum penalty can apply. But for anything short of that, if you're unable, it's just a case where you're unable to prove your innocence. I mean, there has to be a much lesser consequence for a trial which is conducted that way.
On this issue of burden of proof by the state, I think it becomes very problematic. I entirely agree with Eugene what he has said, but there's one issue is the how do you reconcile with the prosecution having to prove beyond reasonable doubt when you have dissenting judgment in the bench? For example, in Jabing's case, it was 3 versus 2. So there is an element of doubt already created in the 2 judges out of the 5. So which is like almost like 30% or 40% of the bench is created. I mean, beyond reasonable doubt, what is it? I mean, if you talk about beyond reasonable doubt, what is the amount of doubt that you need actually to defeat the prosecution's case? Sometimes we talk about 15%, 10%, but here it's like a gaping hole of 40%. So in a situation of death penalty, I think it's important that we have good examples from other countries where you can have, it will be a better approach in the judicial structure to have a unanimous decision-making process, which means all judges must agree. If one dissent, then the death penalty has to be set aside.
Mr. Eugene, maybe I misheard you. Did you say criminal revision is not possible in the 33B MDA situation?
Now, what 33B says is that no action shall lie against the public prosecutor, save that where you're arguing that they made the decision with malice or bad faith. So what that means is that ousts the usual judicial review grounds of when it's the fact that, or the argument that the administrative authority behaved unreasonably, or there was a lack of natural justice, no transparency. You don't know what is it you have to fulfill in this test of cooperation. So usually you have, where you have an executive or any administrative body making a decision, that decision is always challengeable in court, simply on the grounds of judicial review, not about whether the decision that they came to was right or not, but rather whether proper safeguards and a proper procedure was followed in the judicial making process. Now, under Section 33B, you cannot take up judicial review unless you are making the argument that the AG acted in bad faith. Other than that, you cannot bring an action against the AG. You cannot apply for judicial review. Now, why that is wrong, and this is also an argument we made in court, is that you cannot, and Section 33B is not constitution, it's not part of the Constitution, it's ordinary legislation. And I think everywhere, including Singapore, the law is quite clear. You cannot, by way of ordinary legislation, take away or oust the court's jurisdiction to look at something. So that's why I say that part of the legislation is wrong.
Are there any more questions? Okay, I've just been wondering, because in Singapore we do have sting operations whereby the CNB pretends to be a buyer of drugs, and then so as to arrest drug mules.
Entrap.
Entrap, yes, I'm trying not. But yeah, okay, yeah, entrap drug mules. Under such circumstances, where you get arrested, we've seen cases whereby the people who deliver the drugs, they are heavy users of drugs themselves, and in order to get another loan, in order to feed their habits, they did that, and sometimes without knowing the amount of drugs they're carrying. So in such a case, I don't know, how do you even go about doing your defense?
I mean, unfortunately, the way the law stands, and I mean, there are reasons for this, entrapment in itself is not illegal because it is a tool which if properly and ethically used, can aid law enforcement. But the difficulty really is this. When law enforcement start to badger someone or keep throwing the temptation in front of someone and make a criminal out of somebody who wouldn't ordinarily traffic, put the carrot so much in front of him and so frequently that this is, and this would be a person who ordinarily would never have trafficked drugs, does not know about drugs, but because he finds the carrot so tempting, he then starts looking up, okay, how do I get this drug? Because I really want this carrot that's being dangled in front of me. So then you cross the line and you're making a criminal out of somebody who really is not a criminal. So I suppose there are different degrees when it comes to entrapment. It does some good because, I mean, if not, you will never be able to catch people who are really going around peddling drugs. But as to, if you're caught in that situation, I mean, the law is, unfortunately, that it's a fair catch.
Jollivan has a question.
Whether in the cases you've handled, there were situations where they said they were forced to confess or they were pressured to confess certain things, and when there is such pressure and such force, what can be done?
I think in the cases that are more recent, there has been less. There's been less, and I mean, in fact, it'd be fair to say there's been hardly any allegation of threat inducement or promise. I think things have changed since perhaps 10 years ago. So quite fairly, there is not much threat inducement or promise. But what happens, and I think what the complaint really is that these people are kept because drug trafficking is a non-bailable offense. You're kept in prison. Statements are taken from you day after day, and you are not. By law, you are not immediately entitled to counsel, and even if you are entitled to counsel, most of these people do not have the means to go and look for counsel. So there are situations where these people get worn down and give statements, simply because they just despair, lose hope, and give particular statements as to. Unfortunately, because there's no threat inducement or promise in the traditional sense, these statements will be admitted into evidence, but of course, argument could be made on how much weight should be given to these statements.
One last question.
I'm just wondering about the idea of public education. Is there any public education process that helps Singaporeans, most of whom are not legally trained, to understand what exactly Section 33B is? And like, for example, this is the first time I'm hearing about the constitutional challenge that you were mentioning. Is there a campaign, and should there be one?
I mean, as to whether there should be a campaign, I'll leave it to Rachel and Ravi, who are more well-versed with these things. But as to education, I think there is awareness in Singapore and in the region, and I think it would be fair to say in the world, that we have some of the toughest drug laws, and therefore do not traffic drugs into Singapore or within Singapore. As to the technicalities, there's not much education, and there is, and to be fair, I think there's a lesser need for education in relation the technicalities involved in Section 33B, because I think the main message that needs to be gotten across is do not mess with drugs in Singapore, and I think that's an important message. Whatever our views on the death penalty are, I think we are all in agreement that drugs are dangerous and should not be condoned.